All right, perfect. And with that out of the way, Christine, go right ahead.
Thank you very much. It's really good to be with you all today. My name is Christine Johnston. I am Legal Services Counsel at the New Hampshire Municipal Association, and I see lots of names I recognize on the participant list, which is great. Um, I am going to give you information this morning about, I'm going to skip through this beginning stuff while I talk. I'm going to give you information this morning about the legal underpinnings of what planning boards do. Um, I'm going to give you the broad strokes of your various functions, and the speakers who come after me are going to put a little more meat on those bones. They will get more into the specifics of exactly how those functions work and what the rules are about how to do it, notice and holding hearings and things like that. Um, and I want a couple of things to keep in mind all through the day, actually, not just while I'm talking. One is that there is a ton of information that we will all be presenting for you. And there's no way that anybody will remember all of it. We don't remember all of it. That's why we wrote it down. So the materials that we have for you will be available to you after the conference, and you can use them as a resource to come back and look at again, not only to find answers, but to give you the information on where to go look for the answers. What statute is it? Who could you call to get an answer? Um, and then also, please keep in mind throughout the day that what people on a planning board or in a land use office in a municipality or at a regional planning commission do is to serve the interests of the public and the community. Planning is all about making communities better for people and preserving the environment and working toward the future. And all of the rules, there are lots of tiny little rules that you have to follow, and I'm going to explain why you have to follow them so carefully. Um, but they all involve protecting people's rights and serving the public properly. So it can be easy to get stuck in the weeds of how things are supposed to work and who is right and who is in charge. But the goal is to serve your community and the public the best that you can. Sometimes it's easy to forget those things, though. So I am going to go over a little bit of legal framework. And talk about conflicts of interest a bit. I'm going to go through the various statutory duties that planning boards have. I will be focusing on planning boards. And then some of the legal aspects of applications. And as I said, I'm not going to get really deep into the specifics of what the rules are um, because other people are going to cover that. So if you've ever heard me speak before, I'm certain that you've heard me say this, and I'm going to say it again because it is important every single time. The fundamental rule of municipal government in New Hampshire is that towns and cities have no inherent authority to act at all. All of the authority that a town or a city or a village district or a school district or a county has to act comes from the legislature through statutes. The legislature can give you authority and they can take it away. It is never enough to say there's no law that says we can't do this. You have to go one step farther than everybody else, and you have to find a statute that says that you can do what you want to do. And that includes your authority to regulate land use and everything about the way that you do it. If there's a statute that says you can do this, then you can do this, but not extra stuff. Um, if there's a statute that tells you how to do something, that's how you have to do it. If it gives you options, those are your only options. Um, there is a little bit more latitude in that you have to find a statute that says you either can do it or it necessarily implies that you can do it. That would be something like if there's a law that says you can employ contractors to do things for you, it necessarily implies you can pay those people, things like that. And the reason, which I think is really interesting, is this comes from the New Hampshire Constitution. Um, there are other states that have a constitution that says the state does these things and towns and cities do these things. There are also states whose constitutions say the state does these things and everything else is left to the towns and cities. That's what Maine does. New Hampshire's constitution says The state does these things, and that is all it says. It doesn't say anything about towns and cities, and it gives you no authority at all. So it's helpful to keep this in mind when you're looking at things so that you're asking the right questions. Always look for where is the statute that gives me that authority and how does it tell me I need to do that? The authority to regulate land use comes from RSA 674 generally, and RSA 674-16 gives towns and cities the right or the ability to adopt zoning ordinances. And all land use and zoning regulation comes from statutes, so you have to exercise that power in the way that the statutes tell you. So what that means is that you can't have an ordinance or a regulation or a rule of procedure that isn't authorized or necessarily implied by a statute. You have defined authority. One of the reasons that land use regulation is so fraught sometimes, and the reason that judges get so worked up over it, and the reason that judges get worked up over the procedures in particular, is that every decision that a planning board makes has some impact on property rights. And the Constitution, both the New Hampshire and the federal constitutions, are very, very protective of private property rights. They both say that the government can't take property without compensating the owners in a fair manner. And going along with that, you can't restrict what people can do with their property because that restricts their ability to use and enjoy it the way that they want to. Now, obviously, living in society, something has to give. We have to allow, at some point, we have to allow some kind of regulation. So everything about zoning restricts people's property rights a little bit. And courts over the years have figured out how far you can go. There's no really bright line, but that's what they're usually trying to figure out. Does this regulation go too far, not too far? And all of the procedural rules that you can get all bound up in are in place because they are there to protect people's property rights. Every decision that you make will affect somebody's property rights. And if you're going to do that, courts say you have to give them due process. And part of that is giving them the ability to be heard, giving them notice, treating people equally. And that's what all the procedural rules are trying to get at. At the bottom of all of this, and it can be tempting to forget this or ignore it, you have to be reasonable. Follow the procedural rules. Sometimes you have to do more than the minimum that's required because a judge is always going to expect that you are acting reasonably, even when nobody else is. Even when the applicant is not acting reasonably, the abutters are not acting reasonably. Judges don't have a lot of patience for municipalities that don't act reasonably. Having many times been the lawyer defending a town or a city standing in front of a judge, it is a lot easier to defend what you do when you have gone at least as far as the law requires you to go, and maybe even a little farther. You can always provide more notice. You can always give more process. You can always be fairer. And when an applicant or an abutter is acting unreasonably, give your lawyer every tool that they need to defend the decision that you made. So the process that's required to protect property rights, all of the things on this slide, there's a statute somewhere that requires you to do these things, more than one in some cases. So all of the people who will be affected, that's every person whose property will be directly affected by the decision that you're going to make or the application that's being filed. All of those people get notice of what's happening. They all get a meaningful opportunity to be heard on that proposal at a public hearing. They get to be there. They can have someone else speak for them. They have the right to a decision on that issue by an impartial tribunal, people who are not biased one way or the other in an unfair way, and I'll talk more about that. They have a right for you to deliberate based on the evidence and the facts. Your decision needs to be grounded in the information that you received, the facts that you find from that evidence, and relating that to whatever the standards are for that application. They have a right to a written decision with reasons that explain why you decided the way you did. and the ability to appeal if they think that you've made a mistake, whether you did or not. So these are the things that all of those rules are getting at. There is a line of cases from the New Hampshire Supreme Court that sets out very clearly that municipalities and planning boards, zoning boards, the staff that work with them, every land use board has an obligation under the Constitution to assist the public. It is a reasonable assistance that you are obligated to provide. And they want you to work with people, with the applicants, with people before they apply, with the abutters, with people who have questions. You're not supposed to be, you're not always supposed to be in an adversarial position to the public. You're supposed to help them out. Now, that does not mean that you have an obligation to tell everyone how to get their project approved or how to defeat a project that has been proposed. Your duty is to provide people with the information about how the process works. So that means easy things like make your ordinance and all of your regulations and your rules of procedure and your application forms and your fees available. If somebody's asking you questions about those things, make sure they know where to find them. If you can put everything on your website, that is the best. Don't make it hard for people. If they come in with questions, how do I apply for this? What do you think I need to do? You don't have an obligation to tell them how to get it approved, but you do have an obligation to help them figure out what they need to do to get in front of a board. There are opportunities to provide feedback. You can discuss what their options are. You could apply for a variance, or you could change this one thing, and then you wouldn't need a variance. Or you could, tell them what their options are. There is at least one case where the Supreme Court, the town that was in front of the court said, it's not our job to help people figure out how to do this. We just decide applications when they come in. And the judge said, you need to get in the business of helping people figure out what to do. So assume that the judge will apply the same standard to you. One of the things that I talked about was that everyone has the right to an impartial tribunal. And that means that you don't have a conflict of interest when you are deciding somebody's application. A conflict of interest is a situation where a person can't participate because they can't be impartial. And that means, so the conflict there is that a person on a planning board, we'll just focus on planning boards here. If I'm on a planning board and I have a personal interest, that is now in conflict with the public's interest, which is what I am supposed to be dealing with. I'm supposed to look at everything that comes before me and not already have decided. I'm not supposed to be unfairly biased one way or the other. And these situations can come up in a variety of ways. It could be because I hold another position that where I've already made a decision about this project or this application. I might have a personal relationship with one of the people involved or a financial interest in the outcome of this matter, or I just have a personal bias about something. Those situations arise all the time, and there is nothing illegal or unethical about having a conflict of interest. You have alternates because it is absolutely impossible to serve on a planning board in the town or city where you live and never have a conflict of interest. It's going to happen at some point. So it's fine if it does. The only problem is if you don't handle it correctly. Happily for you, there is a statute that explains when you have a problem and you need to step down. If you are on a planning board, you are not allowed to participate in a hearing on an application or the decision on an application, anything that specifically involves someone's property, if you have a direct personal or pecuniary interest in the outcome, and pecuniary is financial, you stand to gain or lose something here. If that interest differs from the interest of other citizens generally, or if you would be disqualified to act as a juror on this matter if it were in a court. So I said earlier, one of the things that could lead to a conflict of interest is if you serve in another capacity. There is a new statute. This was always the case, but now there's a law that says so, and it takes effect on June 21st. It says that if a planning board member also serves on a zoning board of adjustment, and that member has already sat and decided something for this project as a member of the ZBA. Someone went to the ZBA, they got a variance, and now they're in front of the planning board trying to get site plan approval, say. If that's you and you served already on the ZBA for this application, you are now required by law to recuse yourself from the matter when it's in front of the planning board. The same thing is also true in the opposite direction now. If you decided something on a project sitting on the planning board and you're also on the ZBA and that decision gets appealed to the ZBA, you are required to recuse yourself. You always should have been doing that, but now there's a law that says so. So let's look a little bit more at this. So the planning board statute says that you're disqualified if you have a direct personal or pecuniary interest, or if you would be disqualified to act as a juror. So here's the juror standard. And it's all the things you might think. These are things that would make you not indifferent. So if you expect to gain or lose upon the outcome of the application. So here, a great example is if I am a realtor and I sit on the planning board and I already work with the applicant, there's a developer and I already know I'm going to get to sell the lots if this subdivision application is approved. I am absolutely, without a doubt, disqualified from sitting on that case because I stand to gain or lose money based on the outcome. If the subdivision application is not approved, I don't get my commission on selling those lots. That's an easy case. They tend to be a lot more in the middle. If I'm related to either party, relationships are difficult to, it's difficult to say a bright line. Usually if it's a spouse, we generally say you should recuse yourself, but you could have a very close relative with whom you have no relationship. You could have a rather distant relative and you're very close to them, or you really hate them. It could go either way. If you've advised or assisted either party, if I'm a wetland scientist and one of my clients is now before my board, depending on the relationship, I might have to recuse myself. If you've directly or indirectly given an opinion in that case, if I've already spoken out against this project in public in some other forum, and now I'm going to have to sit and decide the application, I have a bias. I have already made up my mind before they got here. If you work for or are the boss of one of the parties, or you actually have a bias, these are reasons that you might need to recuse yourself. And it's hard to give bright line rules on any of these things. But these are the things that if they come up, you should be asking some questions. And that's a theme of today is you won't remember all of this, but if it can make a little flag go up, you say, oh, I remember there was something about that, go and look. You can always get back into these materials. So conflicts of interest they can apply to any kind of activity that you do. As I'm going to explain a little further in a few minutes, the actions, the duties that a planning board has encompass legislative activities and quasi-judicial activities. You're not technically judges, but when you're deciding somebody's application, it's referred to as a quasi-judicial action. And the way conflicts of interest will affect those things depend heavily on whether the action you're taking is legislative or quasi-judicial. So a legislative action is something that affects everybody kind of generally. They're more policy level decisions. These would be things like amendments to the zoning ordinance or drafting a zoning ordinance, subdivision regulations, site plan regulations, rules of procedure. These are things that generally affect your community and they're policy level decisions. When you're doing that, you have to act in the public's interest, but you're not strictly required to be indifferent the way that you are for a quasi-judicial action. If on the other hand, the action is something that affects the rights of specific parties For a planning board, it would be something that affects a particular piece of property and the rights of the owners and the easement holders and the abutters to that property. These are situations where you have an obligation to notify and hear specific people, not just the public in general. You have to weigh the evidence that is provided to you against the legal standards for deciding that application and make a decision based on those things. And you have to be indifferent. You cannot come into it with a bias one way or the other. And so the impact of participating when you have a disqualifying conflict is going to be different. When it is a legislative action, if the person with the conflict participates anyway, a court will only invalidate the board's decision if the person with the conflict casts the deciding vote, if they are the reason that the decision went the way it did. On the other hand, if it's a quasi-judicial action, if you are deciding a subdivision application and you have a disqualifying conflict of interest and you stay in the case and you hear it and you vote, the court will automatically invalidate your decision and remand it back to the board with instructions to start again without the disqualified person, even if the decision that the board made was otherwise absolutely perfect. All of the procedures were followed to a T. The decision actually is supportable by evidence in the record and meets the standards. If a person with a disqualifying conflict participated, courts get very concerned about that and they will undo it and send it back to you. And that is a huge waste of time. So my advice, of course, is not to do that. So just as a quick example, as I said, speaking publicly can be a problem. So if in this case from 2019, there was an application for a conditional use permit and the planning board had to decide it. After the hearing had ended, but before the board had deliberated, two of the planning board members posted on social media comments that opposed the project. And publicly, everything you do on social media is public and it's there forever, even if you think you got rid of it. One of those members was asked to recuse himself, but he did not do it. And he sat and deliberated with the board and voted to deny the application. And the Superior Court said, no, 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 no. I'm not even going to get to the merits of the decision. You obviously had made up your mind before deliberations started, and it threatens the integrity of the deliberative process. And the reason that I want to talk about this case is A, it's a classic example of when someone should have recused themselves. And B, not only does it waste everybody's time and money, because now they had to pay their lawyer to go and defend that decision, even though the lawyer presumably told them, you're definitely going to lose. There's nothing I can do here. It also undermines trust in the planning board as an impartial board. And that is really important because once you have lost people's trust, it is extremely difficult to get it back. So when there's a conflict, what do you do? The hardest part about all of this is that the person with the conflict of interest is the one who has to decide to recuse themselves. No one else can force them to do it. Even though there is a statute that says in particular cases you are required to do it, it's still the person with the conflict who has to make the call. That doesn't mean that they can't get input from other people, though. Our advice, generally speaking, most municipal lawyers will advise that if you think you have a conflict, disclose it to everyone at the earliest possible opportunity. When the application comes in, at the first meeting where you are going to decide whether the application is complete, disclose that you have some kind of relationship with one of the parties or something, whatever it is. And either at that point, if you know you have a conflict and you shouldn't participate, just recuse yourself right then. If you're not sure, see if anybody objects. If nobody objects and you have disclosed the conflict, there are multiple court decisions that say the people who could have objected have waived their right to object. Now, if you really know you have a conflict, you should step down. But disclosing it and seeing if anyone objects is a good way to go too. You can also ask your board to take a vote on whether they think you should step down. The result of that vote is not binding. It is advisory only, but it can be very helpful. It also can be a double-edged sword. If you ask your board to take that vote and they all say, yes, you should step down, and you say, yeah, but I'm not going to do it anyway. That doesn't look so great to a judge. So maybe if everyone says you should step down, just do it. When in doubt, my advice is always to step down. Now, I will say that NHMA's advice is intended to be conservative, and I, as an attorney, have always been conservative. Um, when you do have a conflict, the proper way to handle it is to recuse yourself, not to abstain. Abstaining is never the right way to go. If someone participates in the hearing, participates in the discussion and deliberation and all of that as a board member, and then says, oh, but I won't vote and that will fix everything, that does not fix everything. Because a court will say, we have no way to evaluate how much you influenced the board by participating in the hearing and the discussion. Just because you didn't vote, that doesn't undo the damage you probably did. So you want to recuse yourself. When you recuse yourself, the proper way to handle it is to do it as early as possible, to step away from the table, do not sit with the board, go sit with the public. Because the effect of recusing yourself is that for that matter, for that application, you are not a board member. You are a member of the public. You might also be the applicant or an abutter, and you have rights in that capacity. But if you're neither of those things, you're just a member of the public. So what you do is sit with the public or leave the room entirely. That would be ideal. But you are a citizen, so you get to stay. Sit with the public, only speak as a member of the public when the public is allowed to speak. So it's fine to comment when you have recused yourself, but only in the same manner that any other member of the public could speak. So when the chair during the hearing says, all right, now we'll hear from the public or abutters or whatever you are, that's your time and you get to talk. But it's best to begin by saying, I am not speaking as a board member. I am recused. I am speaking in my personal capacity. And you are allowed to do that. But just remember, for that application, you are not a board member. So you don't do anything that makes you look like a board member. And always, always, always avoid posting anything on social media about any application that is in front of you now or might come in front of you later. Just don't do it. Or speaking in other people's meetings too. And if you do think that it's more important for you to participate as a member of the public because you have such strong feelings about it, just recuse yourself. That's why you have alternates. And then you can say whatever you want. Okay, I am going to go through your statutory duties, and don't get hung up here in the details because other people who are speaking after me are going to cover a lot of this stuff. I want to talk about I want to give you an overview of what planning boards do. So you have three basic kinds of functions. You have planning functions where you're trying to look at the big picture. Then you have legislative functions, and your planning functions and your legislative functions are on that little slide I showed before. They all fall under the legislative umbrella as far as conflicts go. Then you've got regulatory quasi-judicial functions, and that's when you hear and decide applications. And that's when conflicts are really a big deal. I'm going to go through all of these things a little bit. So the planning board is the body that creates the master plan. The purpose of a master plan is to figure out what the best and most appropriate future development of your community in the context of its larger area would be. And that is going to help aid you in designing ordinances and performing all of your other duties in a way that achieves principles of smart growth, sound planning, and wise resource protection, as the statute says. The master plan is aspirational. It is not regulatory. It is not enforceable. It's a wish list. It's an educated wish list where you say, this is what we think makes the most sense generally overall as these big overarching guiding principles to help us as we figure out what the steps are to get us there. There are a couple of mandatory sections that have to be in everybody's master plan. The vision section gives you principles and puts things in priority, and a land use section, which talks about how the land is used now and what future uses might be appropriate. And this is very heavily data-based. You have to do a lot of research before you figure this out. And then there are 16 other sections that are optional. You can put some of them or none of them or all of them, depending on what makes sense for you. You can add more over time. A master plan has to be in place before a town or city can have a zoning ordinance or a capital improvements program. And there is a very specific procedure to adopt it in the statute. The capital improvements program can be authorized by the legislative body. That's your town meeting, town council, or city council. It can be either prepared by a planning board or by a special capital improvements committee. And the legislative body decides which one it's going to be. If it's the planning board, then that would be your job. The capital improvements program is a guide that helps the governing body and the budget committee when they are trying to figure out what the annual budget should be. And the way that it does that is it's a list, essentially, of municipal capital improvements that you hope will take place over at least the next 6 years. It should be done kind of on a rolling basis. And it sets out what the projects are going to be. It could be, a large road improvement, and it generally tends to be infrastructure based. The purchase of major capital equipment that you're going to need. There are very often replacement schedules for equipment. The highway department has some kind of schedule. The police department has a schedule. When buildings are going to be built or remodeled, all of those things. And the reason that the planning board does it is because it is supposed to fit in with the goals of your master plan. You are in the best position to know what we should be planning for. And in the capital improvements program, you're going to have priorities of projects. If we have to make choices, we'll do these first. You're supposed to include timing. You can include cost information, where the money's going to come from, how much it will cost to operate these things going forward, if there's going to be revenue that will be generated or could be used toward it. And kind of like the master plan, it is aspirational. It's a planning tool, but it is not regulatory and it's not enforceable. So if your capital improvements program shows that improvements to the road infrastructure in a particular area where somebody comes in and wants to do a massive subdivision, if you haven't planned for that improvement to happen until 6 years from now, but they want the subdivision today, you can't use the CIP as a basis to deny that application. You might require the applicant to do some of that work or to contribute toward it, but you can't say, we're not going to get to that until later. We're going to do it, but not now. So come back in 6 years. The capital improvements program has to be in place before you can adopt an impact fee ordinance or a growth management ordinance. Okay, moving on to your legislative powers, strictly legislative powers. The planning board has authority to propose a zoning ordinance or amendments to zoning ordinances and historic district ordinances. You don't get to pass them yourself, but you get to design them and write them and propose them so that they can be voted on by your legislative body. There are a lot of procedures that apply to this, and I'm not going to go over those. Amendments can also be submitted to the planning board by voter petition or by the governing body. And the planning board gets to say whether you recommend or don't recommend what's been proposed. You don't get to change it, but you can say whether you recommend it or not. There is a new alternative that cuts you out of this process. Your legislative body can authorize your governing body, that would be your board of selectmen or town council or city council, to amend your ordinance. If you still are the only body who can propose a zone to adopt a zoning ordinance if you don't already have one. But the legislative body can authorize the governing body now to amend your ordinance if you've got one in place. It doesn't take your power away. It's just an additional way that things can be amended instead of going to town meeting or going to the voters if you're in a city where you have to vote on things like that. So this is a legislative action. Zoning ordinances and amendments to zoning ordinances affect the whole community, even though obviously they are going to affect each property owner a little bit differently. But as a general legislative matter, this is a policy level decision. Moving down one step, you also have the authority to adopt a bunch of different kinds of regulations. Subdivision regulation, the planning board can be given subdivision authority even if a town does not have a zoning ordinance, and that is still the case in several towns in New Hampshire. Subdivision regulations address the suitability of land for subdivision and the adequacy of streets and access to that land. It does not regulate what happens on that land once it's been subdivided, but you can put in place requirements for utilities and infrastructure and drainage. That all kind of goes with subdividing and streets. Streets are a focus actually with subdivision, and you'll see that in a little bit. Site plan regulations, planning boards need a separate vote of authority from the legislative body to do site plan regulation. Just because you have a zoning ordinance doesn't mean that the planning board is authorized to do site plan review and approval. And when you are, site plan applies to the development or change or expansion of a use for a non-residential use, any non-residential use, or multifamily structures, which means more than 2 dwelling units in a structure. And there are procedures for adopting subdivision and site plan regulations in RSA 675. You also have the option in your regulations to add a requirement or an option for preliminary review before someone files a full application with you. Your ordinance can mandate preliminary review, or it can give it as an option for applicants if they want to do it. Oh, does the addition of an ADU make something multifamily, a multifamily structure? Yes, it does. Because now there's more than one unit, but that's only 2 units, so it still doesn't fall under site plan regulation. So preliminary review, there are 2 different kinds, and they have 2 different levels of process. One of them is less formal than the other. The first one is preliminary conceptual consultation. This is sometimes referred to as the back of the envelope consultation. It's very general. It is not binding on anyone. There is no abutter notification required. It's a conversation that a potential applicant will have with the planning board during a public meeting, but nobody has to have particular notice that it's going to happen. It's just there's a meeting. And you can talk with them about the type of the type of development that they're proposing, how that relates to your master plan, where it would fit in your zoning ordinance, what issues you see that might come up. They come in and they want all of their lots to be too small. And you say, well, here in our ordinance, it says minimum lot size in this zoning district is 1 acre, but all of your lots are smaller than that. And the developer says, well, I need to do that, or I'm not going to get a big enough return on my investment. And then you say, well, are you going to be able to show that you can put a well on all of those lots? And just so you know, you might need to go and get a variance if you're going to do that. And you may want to go talk to the zoning board. And so you talk with them about all of those things. What your procedure is. If they come in with a project, you can tell them what they're likely to require. Are they going to need site plan approval? Do you think they might need a variance? Are they going to need to get a special use permit? Are there other permits out there that you're aware of? Do you think you're probably going to want a site visit? You can tell them how your process works for site visits, all of these things. If they come in with something complicated and you could say, we don't know, but we anticipate that we're going to want to hire a consultant and we're going to pass that cost through to you. Those are all things that are useful for a developer to know. So that's preliminary conceptual consultation, not binding. Anything that you tell the applicant does not bind you later. If you say, I think this looks really promising, I think it'll probably comply with our ordinance, you can still deny it later if there's a reason to deny it, a valid reason. Design review is a little bit more formal. It's the next step. They're getting much closer. and it is still non-binding, and you still don't have to have a hearing on it. But with this, you have to notify abutters and publish public notice that there is going to be a design review consultation at your meeting. But it's not a hearing, it's still just a discussion. So there, the applicant is going to come in with more well-defined plans. They're getting much closer. And you can get much more specific with what you're going to tell them based on the information they give you. So this is someone who's getting a lot closer to a formal application. They just need a little more review before they get there. But still, it's non-binding, which is very important. Other regulations that you may be in charge of are excavation regulations. RSA 155E governs gravel pits, essentially. The planning board tends to be the regulator, which is what it says in the statute. It can also, in some municipalities, it's the governing body that does this, but in many of them, it's the planning board. So if you are the regulator in your municipality, you are in charge of permitting. And the law has standards for permitting. It has minimum operational and reclamation requirements. You are also allowed to have your additional regulations that go on top of that if you want to, but you don't have to. The law says which excavations require a permit. Some of them do, some of them don't. There are some exceptions. People are allowed to do excavation incidental to building projects or landscape or highway construction. But if it is an excavation that requires a permit, you're going to have to administer this program, even if you don't have your own separate regulations. But you can, and there's a process in the statute for how you adopt those. So all of these regulations, when you're adopting them, regulations and ordinances, the adoption of these things is a legislative action. Impact fee ordinances. This is something else you might need to write or amend. It's adopted in the same way as a zoning ordinance. It's ordinance level. It's not a regulation, so you can't do it by yourself. You have to have a capital improvements program in place before you can have an impact fee ordinance. And an impact fee is a fee that the municipality imposes on a developer to help meet the infrastructure needs that are created by that development. It's for municipal capital facilities, and there's a list of them in the statute, things that you can make a developer pay for: water, wastewater, sewers, stormwater, drainage, and control facilities for all of those things, roads, municipal buildings and public works, and schools, public safety, and waste disposal. You can cover all of those things. And what you would impose on the developer would be their proportional share of what it's going to cost the municipality to make these improvements. So there are a lot of formulas out there for how you figure this out, but this is the general idea of what it is. Even without an impact fee ordinance, you have the ability to impose what are called off-site exactions on a developer. And the sphere of things for which you can impose these fees is a little bit smaller. You can charge for more things with an impact fee ordinance, but if you don't have one, you can impose these costs as a condition of approval for improvements that are necessitated by a development but are outside the boundaries of the project. They have to be related to the demands that are going to be created by this project. So you might look at the impact that a multi-lot subdivision would have on the road system. If it is an unpaved road and someone is going to double or triple the number of house lots on that particular road, you could probably reasonably draw a line between this development and the need to improve that road. That's what the rational nexus is. There has to be some kind of rational connection between what this development's going to require and what the town is going to need to do to upgrade its capital facilities to accommodate that. You can only use it for highway, drainage, and sewer and water upgrades that are affected by that development, and only their proportional share. And even if you don't have an impact fee ordinance, having some planning done on this ahead of time can be helpful to help you evaluate it, because suddenly the big project comes in and you have no idea how to look at it. When that sort of thing happens, this is a really good time to talk with your regional planning commission. They can be extremely helpful in walking you through that if you've never done it before. Driveway regulations. I said earlier that their subdivision approval is tied in inextricably with streets and roads. Um, the authority for driveway regulations is not found in the planning statutes at all. It is found in the transportation highway statutes. RSA 236.13 gives the planning board or the governing body, there's a choice at the local level, the authority to regulate driveways on town roads, not private roads, not state roads, class 4, 5, and 6 roads. In order to do it, you must adopt driveway regulations. You can delegate the actual permitting to the road agent or some other official, and that frequently does happen, but not in every case. There's a new time limit to act on driveway permit applications. You have 65 days to do it, which is just there to keep you from sitting on it. The purpose of driveway regulations is to regulate the connection with the public road and the impact that the driveway might have on the public road. It's not about the use of the land away from the public road. So I've seen a lot of driveway regulations that try to regulate how long a driveway can be, what the grade of a driveway can be, whether it has turns and whatever. Now, there are other ways to do that. But driveway regulations under RSA 236 are not it, because the focus of a driveway regulation is to deal with the connection with the public road. So what it's supposed to deal with is sight lines, the grade insofar as it affects water runoff onto the public road, because obviously if water is running on your road, it can degrade the road. It can also freeze and cause a safety hazard. Keeping things off of your road, protecting the integrity of the side of the pavement, all of those things, drainage ditches, not impeding the functioning of your ditches on the public road. And the planning board has continuing jurisdiction over every driveway that enters onto a class 4, 5, or 6 road in your town or city, even if that driveway was in place before the driveway permit statute, even if it was put in illegally and no permit was ever issued. You have continuing jurisdiction, and you can order the property owner to fix a driveway that becomes a hazard to the traveling public or a threat to the public road integrity. And this comes as an unpleasant surprise to a lot of property owners. If there's a culvert running under the end of somebody's driveway and it's not sufficient anymore, it's clogged or it's too small or it's sending water in the wrong direction, you can tell them to fix it and they have to do it. And if they don't, you can bring an enforcement action. Some other things that you can regulate: rules of procedure. You are required to have rules of procedure. If you have rules of procedure that you've never read or they are 10 years old, please, please, please take a couple of meetings, deal with your rules of procedure, look at them. Lots of things have changed in the law over the last couple of years that may make your rules outdated. And as I said right at the beginning, you can't have a rule or a regulation or an ordinance that violates any law. So if your rules of procedure don't comply with current requirements for application processes, public hearings, notice, all of that, your rules don't work well. You need to fix those. You can adopt your rules of procedure at a regular meeting. You don't need a hearing on them. No, you do need a hearing, but I think you need a hearing, but you can adopt them at a regular meeting. You have to file them with your municipal clerk. You have to address how your alternates can participate in your activities. Do they get to sit with the board? Do they get to participate in hearings, even if they're not designated to sit in place of an absent or recused member? How does that work? Your rules have to comply with the law, and they can fill in the gaps in the law. And there are lots of gaps. Um, you should become familiar with your rules. You should follow them. There is a statute that says that procedure is supposed to be, it's supposed to work, but there's some flexibility. And if you don't technically follow everything, you might not have a problem. I can tell you that the one time you decide not to follow your rules, there will be, excuse me, an applicant or an abutter or an attorney representing one of them that will make the biggest deal ever out of the fact that you didn't follow your rules. Just follow them. If you're not going to follow the rules because you have a legitimate reason, explain what it is. And if your rules don't work for you, you should change them. Don't make your rules so complicated that nobody can use them. They should lay out how you're going to do things. And if you decide you want to change how you're going to do things, you get to change your rules. They're your rules. Work with them. They should be a living sort of thing. You shouldn't just do them once and then ignore them forever. A couple other things that you do, lot mergers. People get confused about this stuff. There is a statute that says that a property owner has the right to merge two or more contiguous, that's abutting, lots. They are allowed to do it, and in most cases, you can't say no. This is something that you do, or you can designate somebody else to handle it for you. There are some larger communities that have their planner do it. You don't need a public hearing. You don't need any public notice. They file the application, and you have to approve it unless it would violate your current ordinances or regulations. Most of the time, it does not. It's when people want to subdivide that they have more of a problem. If there's a mortgage on any of the lots, you have to see consent in writing from the lender. They do not need a survey in order to merge lots. What you do have to do is record a notice of merger, and that's going to include the map and lot number and the recording information for the deeds that they have to those lots. All of that will be on this notice of merger, which should be part of your application, and then that gets recorded at the registry. My advice is you record the notice. Don't leave it to them, because then you'll be chasing them if they don't do it, and you have this thing you approved and it didn't get recorded. The best way is to require with the application, they pay the recording fees to you, and then you handle the recording, because then you know it gets done properly. You don't need to create any regulations for this. So then, acting on applications, that is the other big piece. So all of this other stuff that I've talked about is stuff that people who aren't on a planning board don't see very often. What they see is this piece, that you are acting on applications, and this is your judicial, quasi-judicial activity. You are required to notify all of the parties. That's the applicant and the abutters and people who hold easements on the property. You're required to notify the public as well. You're required to hold hearings and get information and evidence and testimony from the parties and any other person who wants to give it to you or who you want to hear. And then you take that information and you weigh it against the statute or the ordinance or the regulation that applies, and then you make a decision. You have to get you have to give them a fair process, and you have to respect the constitutional rights of all of the parties, as I talked about at the beginning. If you make errors in the process, you didn't notify everybody you were supposed to, you didn't give them enough notice, you didn't allow someone to speak at the hearing who was required to be allowed to speak. If you do something like that and someone appeals, you've given them an appealable issue at that point, even if your decision was perfect. And if that happens, a judge may send it back to you. If you make a really big error and your decision wasn't right, the judge might not even send it back. They might just say, well, looking at all of the evidence here, I can see that it should have been granted, so I'm just going to say yes. And then you don't even get a chance to put conditions on it. So when you have concerns about the process, if you think you might have made a mistake, get legal advice. If you aren't sure about the process, ask somebody. It is so much cheaper to get legal advice up front than to pay a lawyer to sort it out later. There is enough work for every municipal lawyer in New Hampshire. without dealing with mistakes that are avoidable. Most of us would very much rather talk with you for 5 minutes and make sure you don't make a mistake than to deal with your appeal for months or years and keep charging you the whole time. I never felt good about that. And again, all of these things have a lot of process involved with them, and others today will give you information about it and resources that you can consult as you go. I am going to talk about some of the legal aspects of dealing with an application. Um, accepting an application as complete. This does not mean approving an application. A planning board is required to do a preliminary step where you decide, is the application complete enough for us to start evaluating it? So when you say accepting the application, don't say approve, because that freaks people out. All you're saying is, are you ready to go? You have to have in your regulations a checklist that specifies, well, you can have it in any form you want, but you need to have a list. You need to tell applicants what they have to submit in order for their application to be complete. Please include full payment of any applicable fees as a prerequisite for completeness. Don't chase them later. The application has to be filed at least 24 days before the meeting at which the board will consider completeness. You are allowed to reduce that amount of time in your regulations if you want to, because the law says that you can. So you can give them more latitude. You can't give them less. So you can't make people you can't require people to file 30 days before your application. You are required to consider whether the application is complete at the next regular meeting after they file it, if they filed it on time, or no later than 30 days after they have submitted their application. They have the right to a process that is moving along at a reasonable pace. Before you consider it for completeness, you have to do full notice to all of the abutters and to the public. You can also include in that same notice, you can say, if it is deemed complete, we will open the public hearing at the same meeting. So that way you don't have to send two notices. You have a discussion and a vote on the completeness during a public meeting, but that is not a hearing. It's just part of your meeting. Your staff, if you are lucky enough to have staff, they can help you tremendously with this part. They can pre-review the application. They can get in touch with the applicant beforehand, which they should, and say, hey, we're missing this one thing. We're missing something else. Did you mean to include something? And an issue about waivers here. So very often an applicant is going to ask for a waiver of some application requirement. Will you waive the requirement for this kind of map or this particular plan or something like that, because we don't need it or it's not applicable to this project or something like that. So if they're asking for a waiver, when you're looking at completeness, either they've included all of the information or they have included a written waiver request of the thing that they're not providing you with their application. So you can consider that as checking off the box. Now, you may decide at some point you're not going to grant that waiver and then they have to submit that thing. But for completeness, a waiver should be sufficient as long as they've actually included a written waiver request that addresses the standards for a waiver. The issue, deciding on completeness. As I said, it's not a hearing, so nobody has the right to speak except the board. But you might need to ask the applicant some questions about that, and that's fine. If you decide something's not complete, you're required to tell the applicant what they're missing, and then they go off and they get it for you and they come back. If it is complete, then your clock starts running. You have 65 days from that point to hold a hearing and make a decision on the application. If the board determines that the project will have regional impact, which I'll talk about again in a minute, 30 days gets added on to that review period because there are more steps you have to follow. Every hearing requires at least 10 days notice to the applicant, the public, abutters, and easement holders. And as I said, you can start the hearing at the same meeting as completeness if you have noticed it that way. The applicant can waive the 65-day deadline if they want to. Remember that applicants want to get to yes. They will very frequently agree to waiver of the 65-day deadline as long as they think that you are moving toward yes. It doesn't mean you have to say yes. But if you are being reasonable and you say, look, there's a holiday, or we, can't get a full board this day, or we are going to need to get a contractor or a consultant to come in and help us with this. We're going to need an extra 2 weeks or something. They will very often say yes. Get it in writing. It's nice if they say it during the public hearing and you have it in the minutes. It's better if they put it in writing. Email is fine. Keep it in your records. If you do not issue a decision within the 65 or 95-day deadline and the applicant does not waive the deadline, a couple of different things can happen. The worst one is that they don't waive the deadline and you don't make a decision. The law says that the governing body is required to approve the application. It gets taken out of your hands, and the Board of Selectmen or the Town Council or City Council is required to say yes. And then it gets recorded and you have no say. Don't do that. The better option is that you are allowed to deny the application without prejudice. This is magic legal language. There's not a lot of it, but this is important stuff. You are allowed to deny the application without prejudice, and that means that the applicant can come back in the future and file the exact same application and try again, which is important. We always thought you could do this, but the law was changed a few years ago to explicitly give you this option, which is fantastic. Proposed zoning changes. Very frequently, there will be an argument about whether a proposed zoning amendment applies to a particular application. And the answer is found in RSA 676:12, paragraph 6. So if you have a proposed zoning amendment and there is a project being proposed that will not comply with that proposed zoning amendment, but it complies with your current ordinance, what you're looking at is which thing got noticed first. So when you're proposing a zoning amendment, you're required to post public notice of a hearing a public hearing on the proposed amendment. When an application comes in, you are required to provide public notice of the fact that the application was filed and that the board will be considering whether the application is complete. Whichever one of those notices goes out first, that one controls. So an amendment, a proposed amendment, is not going to apply to an application if the notice of the board's consideration of completeness of that application occurred before the notice of the public hearing on the amendment. It also applies to proposals that are submitted to a planning board for design review. This is the more formal preliminary review for which you have to provide public notice. Not a hearing, but you have to notify the public and the abutters that you're going to have this design review discussion. If that notice has gone out first, before the notice of the public hearing on the proposed amendment, then the application is not subject to that amendment as long as they file a full application within 12 months of the end of design review, which points out an important thing. When design review ends, you have to document that with the applicant. You send them, you say at the end of that meeting or the end of that discussion, okay, this is the end of design review, when you know it's the end. And then maybe you send them a notice saying, just to confirm, design review has ended. And that way you have that clock going. When you deny something without prejudice, I said that that meant the applicant can come back. The reason that's important is that usually an applicant is not allowed to apply for the same project over and over if they have been denied. Otherwise, they'd just be doing that all the time. You'd never get anything else done. If they want to come back for the same project after you've denied it, the second application has to be different from the first one in some material way, some way that makes a difference. And that can happen in two different ways. One is if there's been a change in the applicable legal standard. If Their classic example is the variance standards in the law were changed several years ago. And a project that was denied a variance before that change was allowed to come back and try again after the law had changed, because maybe the answer would be different. If you have amended your zoning ordinance or changed your subdivision regulations, the person whose project was denied under the old regulations might be able to come back and try it again. They still might not get it, but they would be allowed to come back. The other way is that if the applicant changes the project in some way that addresses the reason you denied it the first time, it doesn't necessarily mean that it will get approved the second time. It just means they've done something. So if they were denied the first time because the lots were too small, and they come back and the lots are bigger, maybe that works. They at least get in front of you. This is, do they get in the door? It doesn't matter whether they would ultimately get approved. Or if it was denied because they didn't have enough parking proposed and they come back with a new parking plan, they can get in the door, and then you evaluate it based on the applicable standards. And as I said, denial without prejudice does not trigger this. A word about developments of regional impact. This is not found in your planning board statutes. It's in RSA 36, and it applies to every application that comes before you. So part of your rules of procedure should include, toward the beginning, when you're dealing with an application, a decision on whether or not this application proposes a development of regional impact. And what that means is that the project reasonably could be expected to impact a neighboring municipality. And there are examples. It might be because of the relative size or number of dwelling units proposed, the proximity, how close it is to the boundaries with another municipality, impact on streets, roads, transportation networks, anticipated light or noise or smoke or odors or particles, impacts on aquifers or water bodies that cross boundaries, shared facilities like schools or solid waste facilities in other communities. When in doubt, you're supposed to come down on the side of a finding that it might have a regional impact. That's the default. So if you're not sure, say yes. You should address this at the same meeting where you decide completeness. If you vote yes, that this is a development of regional impact, within 5 days after that vote, you have to send copies of the minutes of that meeting by certified mail to your regional planning commission and to whatever the other affected municipalities are. And you have to send a copy of the plans to the RPC, and the applicant pays for all of this. And then at least 14 days before your public hearing begins, which means it can't happen that night, you have to notify the RPC and all of the affected municipalities of the hearing and their right to testify. And then you treat them like parties, essentially, going forward. Few other things, and then I'm going to try to answer some questions. Rules of public hearings. I'm not going to go over this right now, but you should have rules that explain how you are going to hold public hearings. And there are lots of examples around the state for how to do this. ODP has a great template for this in their planning board handbook. Talk about time limits maybe on how long people get to speak, the ordinary order of when people will speak. We always advocate giving the applicant the last word because it's their application, right? Try to follow your own rules and explain why you're not following them. If you don't do that, the board should ask questions. The hearing is your shot, your only chance to get information and ask questions. So any questions you have of the applicant or the abutters, this is your time to ask them. Do not wait. Once you have closed the hearing, you don't get to ask any more questions of the applicants or the abutters. Your rules are required to talk about how alternates can participate on your board. Your rules should talk about when your alternates get to sit with the board, when they are allowed to participate and ask questions. We highly recommend that you let your alternates participate in the hearings. Let them sit with the board, let them ask questions, even if they're not designated to sit in place of someone else. Because A, this keeps them engaged and you need alternates. And B, if they suddenly have to step in for a member, they're prepared. However, once the public hearing is closed and the board is going to deliberate, the alternates do not participate anymore unless they are formally seated in place of someone who's absent or recused. Who gets to speak at your hearings? The applicant always gets to speak. Abutters always get to speak. Any holders of conservation, preservation, or agricultural preservation restrictions always get to speak. Any other person with a direct interest in the matter. They're not a direct abutter, but they are the next one over and the stream goes right through their lot too. So if someone comes to you and demonstrates their land will be directly affected by the proposal, the law says that you have to let them talk. You can also allow any other person that you want to speak. The general advice is let everybody speak who wants to, unless it's a complete circus. If it is a valid question to ask if they're a resident of town, people do not have to tell you their name. People do not have to tell you exactly where they live, all of that. You can ask them those questions. If they don't want to tell you that, ultimately give their testimony and opinions the weight you think they deserve. You might give more weight to someone who is almost an abutter than you would to the person who lives all the way across town. You might give more weight to the person who tells you that they are a resident than a person who won't tell you at all. I mean, don't tell them that, just let them speak. Very important information. Closing the hearing. Okay, and continuing a hearing. You do not have to provide new notice to everyone to continue a hearing to another day, as long as you say the time, date, and place of the next session before the end of the current one. People are presumed to have attended the hearing if they were interested, and then they would hear that information, or they can read it in the minutes. In the meantime, do not have contact with the applicant or any abutters. Do not talk about the application. You live in the same community, so you might run into each other. Don't talk about it. Try not to talk with them at all. Have your staff do any communicating with them as necessary. Don't close the hearing too soon. Did everybody get heard? Have you asked all your questions? Formally close your hearing. The chair should say, I am now closing the hearing. And that is sort of a magic time. No one else gets to talk after that point except the board. No more information gets submitted, no more testimony, no more letters, no more nothing. Anything else comes in, you are not getting it. They should be told the hearing is now closed. This is the point where you might want to get some legal advice. If you need legal advice, you should get it. It's cheaper to do it beforehand than later. You can have a consultation with your legal counsel, which is not a meeting under RSA 91A, or you can meet with them in non-public session and you can discuss their written legal advice in a non-public session, or not written legal advice. So seek it out. Then you deliberate. Deliberations are held during a public meeting, always, 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 never in private. All of the members who are sitting get to talk, and everybody should. Other people are going to talk a little bit more about this, but you are supposed to make your decision based on the standards that are in your regulations and the ordinance and the law, and that is it. You can deliberate immediately or another night. You do not have to provide specific notice to anyone that you are of which day you're going to deliberate, but you have to obviously post notice of when you're going to have a public meeting, and you probably want to put it on there. You always can provide notice, you're just not required to. You're required to issue a written notice of decision. If it's a denial, you have to say why. If you approve it with conditions, you have to include all of them in the written decision. If you approve it or deny it, you have to include findings of fact. Which facts were important? Which facts led you to either approve or deny the decision? It has to be on file and written with the meeting minutes within 5 business days after the vote, and you have to make it available to the applicant at the same time. The method you choose to do that is up to you. If you have a tie vote, you have not acted. It is not a decision. You need to keep talking and try again. A tie vote doesn't mean a denial either. It just means you didn't decide, and you should put that in your rules of procedure as well. I have a few more slides to get through, and I'm out of time. Conditional approval anything the applicant says to you, you can say, anything you say, we're incorporating in our decision. But as a practical matter, if you don't write it as a condition in the written decision, it is very hard to enforce it later. Your lawyer will thank you and you will come out better. Either put it as a condition on the plan that gets signed and recorded, or put it in your written decision. Conditions might be, there are two kinds, conditions precedent and subsequent. Precedent means they have to meet this condition before they get to record the plan and go ahead with their development. Subsequent is more of an operational going forward kind of condition. Performance bonds, I'm going to skip this part. Actually, I'm not. The law has just changed so that if you have required an applicant to post a performance bond for completing roads, you now have to allow road and utility construction to start without the bond, but before any lots are sold in a subdivision or any residential building permits are issued, the bond has to be in place. That is a recent change. Vesting. This law also just changed. It used to be 2 years and 5 years. Now it's 3 years and 7 years. So if an applicant undertakes active and substantial development or building within 3 years after they get final approval of their plan, and if they get to substantial completion of the approved project within 7 years, they are protected forever from changes in the zoning ordinance that would affect their plan otherwise. The important thing I want to get through is the time limits have changed, 3 years and 7 years. So if your regulations or your ordinance are still built on 2 years and 5 years, you need to change those. And then one word about appeals, and I know I'm over time. The applicant, abutters, or any person aggrieved by your decision has the right to appeal within 30 days. There are 3 places they can appeal. Appeals to the ZBA are of any aspect of your decision that is based on your construction, interpretation, or application of a term in the zoning ordinance, not your regulations, the zoning ordinance. Anything else gets appealed to, anything about the procedures, anything about the subdivision regulations or your site plan regulations gets appealed either to Superior Court or the Housing Appeals Board. The Housing Appeals Board can make decisions, can hear appeals on anything involving questions of housing or housing development. The Superior Court can hear anything that's not supposed to go to the ZBA, and the choice is up to the applicant. They can decide which way they want to go. The last thing I want to say is when there is an appeal, the only information that a judge or the Housing Appeals Board or the ZBA is going to get is the information in the record, which means the minutes, the application, any correspondence that you've had, any information that's been provided to you by the applicant or the abutters. Assume that there's no other evidence. There might be, but generally there is not. So that means your minutes need to be clear. Your records need to be complete. If it's not in the minutes, it is hard to prove that it happened. If it's not in your written decision, it is hard to prove that it applies, that you did that. It's hard to prove what your intent is. So make the record as complete as possible, because then you have a better shot at getting your decision upheld. I am out of time. Happily, there's a Q&A at the end. So I am going to hand control back over.
All right, perfect. Here, I'll take control there. Thank you so much, Attorney Johnston. Yeah, that was fantastic. Sorry, we don't have time for questions or anything, but we have a Q&A session, as Attorney Johnston said, at the end of the day, where we will be answering any outstanding questions. I think Christine actually did a great job of you answered a few questions sort of along the way. I saw them come in, and then a few slides later she answered them. So anyway, we are going to take a quick break, and I believe we're coming back at 10:30 for John Christ's session. And yep, we'll be back at 10:30 and for the planning board roles and responsibilities, and we'll keep this going. If John has any time, might ask him a few of these questions at the end as well. And again, there's going to be some overlap on some of these topics, and maybe looking a little bit deeper into some of them as well. So anyway, go take a break, grab a snack, and we will be back. Don't log off, stay logged in, and we'll be back in about 8 minutes. All right, thank you all.